And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
So we need to talk about a major development at the High Court, because the Supreme Court just dropped an 8-1 emergency order that fundamentally rewrites the rules for Second Amendment preservation acts across this entire country. 8 Supreme Court justices just aligned on a ruling that will determine, once and for all, whether states can actually push back against federal gun regulations they view as unconstitutional. This is a massive shift in the legal landscape, and you need to hit that subscribe button right now because you'll want to stay updated on every single development as this case unfolds. When you look at the numbers, the 8-1 vote breakdown is actually one of the most lopsided decisions we've seen on a Second Amendment-related case in recent history. Usually, these cases split right down the middle, 5-4 or 6-3, along predictable ideological lines. But what makes this specific vote so shocking is that justices appointed by both Republican and Democratic presidents joined the majority. This signals that we aren't just looking at a political preference here. We're looking at a fundamental shift in constitutional interpretation. Only Justice Jackson stood alone in her dissent, arguing that the majority's approach could undermine state sovereignty in ways that go far beyond just firearms regulation. Her dissent alone spans 14 pages and cites nearly 50 different precedents, making it one of the most thoroughly documented solo dissents of the current term. Now, you have to understand the urgency of this. The Supreme Court typically grants emergency relief in fewer than 15% of requests. Yet here, they acted with incredible speed, issuing this order within 72 hours of receiving the final briefs. To understand why this is such a big deal, we have to look at how these Second Amendment Preservation Acts, or SAPA laws, actually work. Most people don't fully realize that these laws operate through 4 very distinct legal mechanisms. First, they establish what's called a state constitutional floor. And this means a state declares its own interpretation of the Second Amendment, which can be much more protective than the current federal interpretation. For example, Missouri's version explicitly defines 22 different categories of federal gun regulations as unconstitutional, including things like registration requirements and capacity limits. Second, SAPA laws cut off what legal scholars call cooperative federalism. This is the common practice where states voluntarily help federal agents enforce laws using state resources and manpower. Third, these laws create heavy financial penalties to deter state officials from cooperating. In Missouri, any state employee who assists federal gun enforcement could face personal civil liability of $50,000 per violation, payable directly to the affected citizen. Since that law passed, over 120 Missouri law enforcement officers have formally certified that they will not participate in federal task forces, just to avoid that massive personal liability. And fourth, most controversially, these laws allow private individuals to sue state officials for compliance. It's a powerful enforcement structure that puts the power directly into the hands of the citizens. But here's the part that nobody is talking about on the news, the anti-commandeering precedent. This legal doctrine didn't even start with gun rights. It came from cases about radioactive waste and marijuana. Back in 1992, the Supreme Court ruled that the federal government couldn't force states to administer federal programs. Then, in 1997, Justice Scalia famously wrote that the federal government cannot command a state's officers to enforce a federal regulatory program. This established a very clear rule. States have every right to refuse to help enforce federal law. Since then, 17 different states have passed laws declining to enforce various federal regulations, and none of those laws have been struck down as unconstitutional. So the real legal question here is, do these SAPA laws go beyond mere non-cooperation and turn into active obstruction? The courts have been very inconsistent on this. The Ninth Circuit allowed California to refuse to help with immigration enforcement, but the Eighth Circuit struck down Missouri's refusal to help with gun enforcement. It feels like a double standard, and that's exactly why this is heading for a showdown. Now here is where it gets really interesting. We've seen a complete reversal in how the Department of Justice is handling this. The Biden administration's DOJ originally filed the lawsuit, arguing that Missouri's law was unconstitutional in its entirety. They wanted millions of dollars in legal costs and a permanent ban on any state attempting to limit federal enforcement. But when the Trump administration took over in early 2025, they took a very different middle ground position. The Trump DOJ conceded that portions of the law are actually protected under the Anti-Commandeering Doctrine. They essentially admitted that a state can refuse to cooperate, but they still argued that the financial penalties for officers went too far. This shift in the DOJ's position is a huge signal to the courts that the federal government is no longer united against these state-level protections. The Eighth Circuit Court of Appeals issued a massive 73-page opinion on this that actually defies logic. On one hand, They acknowledge that Missouri's policy is structurally identical to sanctuary city policies that have been upheld elsewhere. But then, they claimed that Missouri's motivation was the problem. Effectively, the court created a troubling new rule. They said states can refuse to enforce federal law for neutral reasons, but not if they are doing it to protect constitutional rights they think the federal government is violating. It's a bizarre contradiction. They're basically saying you can refuse to help the feds if it's about money or resources, but you can't do it if it's about the Second Amendment. Missouri's petition to the Supreme Court highlighted this absurdity, pointing out that no court has ever invalidated California's sanctuary laws despite their explicit political and constitutional language. And remember, Missouri isn't in this fight alone. There are 14 other states watching this case very closely, representing nearly 100 million Americans. Montana, Wyoming, Tennessee, and Oklahoma all have similar laws on the books or in progress. Oklahoma's law even goes as far as declaring 41 categories of federal gun regulations null and void and setting aside millions of dollars for legal defense. If these laws are allowed to stand, the impact on federal agencies like the ATF would be staggering. The ATF estimates that if all 15 of these states stopped cooperating, their ability to conduct investigations would drop by nearly 60%. They would have to relocate hundreds of federal agents just to maintain current enforcement levels. One thing almost everyone is missing is the pre-enforcement problem. Missouri's SAPA law has never actually been enforced because it's been blocked by courts since 3 weeks after it was passed. This means the federal government sued Missouri over hypothetical harms. They brought in ATF agents to testify about what might happen, but they couldn't point to a single instance of actual obstruction because the law wasn't even active yet. Missouri is arguing that you can't throw out a law based on speculation. You have to see how it works in practice first. So, what does this Supreme Court remand actually mean for you? The 8-1 order sends the case back to the district court in Kansas City, but with very specific instructions. The Supreme Court told the lower court they must consider the federal government's revised position and develop a fuller factual record. Practically speaking, this means the blanket ban on Missouri's law is likely to be modified or narrowed very soon. We are looking at a new order sometime in late 2025, and the discovery phase will finally force the feds to prove, with real evidence, that this law actually obstructs justice, which they might find very difficult to do. At the end of the day, while this case is framed as a battle over gun rights, it's really about one of the most fundamental questions in American law: who holds the power? If the Supreme Court ultimately rules that states have the authority to decline enforcement of federal laws they view as unconstitutional, it will fundamentally reshape American federalism. It would give red states and blue states alike a massive new shield against federal overreach, whether it's about guns, immigration, or healthcare. The financial and political stakes here are enormous. Federal law enforcement relies on state cooperation to the tune of nearly $9 billion a year. If states start exercising their right to say no, the federal government's power shrinks overnight. That is exactly what is at stake in this critical Second Amendment preservation fight. As this case develops through the district court and eventually heads back to the Supreme Court for a final ruling, I'll be here to break down every single move. If you want to stay ahead of the curve and understand how this reshapes your rights nationwide, make sure you hit that subscribe button. Drop a comment below and let me know. Do you think the states should have the final say on which federal laws they help enforce? I'm looking forward to hearing your thoughts. Stay safe, stay smart, and I'll see you in the next one.